The Professional Trustee's Guide to Estate Contests and Disputes. Estate contests and disputes can be intimidating for anyone, even a professional trustee. Here, we're going to take a look at some of the questions we're commonly asked about estate and trust contests, estate disputes, and other issues that professional fiduciaries may face. So what are the most common estate contests and disputes? Estate contests and disputes occur when an interested party challenges the validity of a will in probate court. A will is invalid if the testator did not follow state legal requirements, if the testator was not of sound mind, or if a third party illegally manipulated the testator and used undue influence to obtain a document that doesn't reflect the testator's intent. Legal requirements not followed. Testators must follow the specific rules and formalities established by state law when creating a will. These laws vary between the states, but every state requires at least the following. 1, that the testator be of legal age. 2, that the testator meant for the document to be their will, that it was their testamentary intent to create a will. 3, that the testator signs the will. And 4, that at least 2 witnesses who saw the testator sign it or were told by the testator that they signed it also signed the will. If the will fails to meet any one of these requirements, the probate court is likely going to deem the document invalid. Lack of testamentary capacity. For a will to be valid, the testator must be of sound mind when creating the will. Sound mind means that the testator must have the mental capacity to understand 3 basic concepts. 1, that they're creating a will. 2, the nature of their estate assets. And 3, who's going to get their property. It's a pretty low standard. The only standard that's lower is the standard to marry. Under this standard, a person may have dementia and still form a valid will, as long as they understand those 3 ideas when executing the will. Undue influence or fraud. Undue influence occurs when a family member, close friend, trusted advisor, healthcare worker, or really any third party compels or coerces the testator to execute a will or trust in their favor. The influence exerted must be extreme and put the testator under a severe level of distress that causes them to abandon their own free will and give in to the other person's desires. Similarly, a will can be fraudulent if a third party tricked the testator into signing it by claiming it was another document perhaps, or if the third party forges the testator's signature. Another example is where the third party otherwise creates a document through fraudulent means that the testator didn't intend to be a will. Can a trustee be sued? Yes. Trustees have a legal duty to administer the trust for the beneficiary's benefit while acting with skill, care, and caution, essentially as a fiduciary. In reality, serving as a trustee is a thankless task because the fiduciary duty owed to beneficiaries, the highest duty, allows beneficiaries to sue trustees for perceived errors or mismanagement of trust assets. Common issues that beneficiaries complain about that could expose a trustee to liability include 1, trustee theft of trust assets. 2, failing to distribute trust assets. 3, failing to provide an accounting or being transparent about a trust's management. 4, mishandling trust assets. 5, poor investment choices. 6, self-dealing. 7, conflicts of interest. 8, favoring or disfavoring one beneficiary over another. And 8, paying taxes late or occurring avoidable penalties and charges. To protect themselves from liability, trustees should always keep detailed and well-organized records of their activities. They should thoroughly document every transaction, their time, and detail the reasons why they made their decisions. Trustees should also make sure they understand all of the trust instructions and obey them to the extent they're able. Can a beneficiary be sued? Well, unlike trustees, beneficiaries don't have any responsibilities with regard to administering a trust or an estate. A beneficiary simply is there to take, to receive what the trustee is supposed to give them. Since a beneficiary doesn't have a fiduciary duty to the trustee, trustees rarely have reason to sue a beneficiary, unless the beneficiary has stolen or otherwise damaged trust property. For this reason, it's much more common for a beneficiary to sue a trustee than a trustee to sue a beneficiary. Can a beneficiary be removed? Beneficiaries can only be removed under certain circumstances. Beneficiaries may choose to disclaim or waive their interests and remove themselves as beneficiaries. However, a trustee cannot change a beneficiary designation to remove a beneficiary unless the trust document contains language that expressly allows them to do so. That's commonly found in a power of appointment, or if a trust contains other language that serves to disinherit a beneficiary upon an occurrence of some event, most often allowing a trustee to suspend or terminate benefits to a beneficiary with substance abuse issues, for example. How should I handle a problem beneficiary? It's an unfortunate and all too common truth that some, perhaps even many, beneficiaries can be difficult and demanding. In our experience, this type of behavior often stems from fear and anxiety about a lack of transparency in the trust administration process. Beneficiaries may not be familiar with how trusts work or may resent the fact that the trustee has been put in charge of what they consider their property. Even when a trustee is doing everything right, if the beneficiaries don't know what the trustee is doing or why they're doing it, they might be uncooperative, suspicious, and cause problems. Here are a few suggestions for trustees on how to handle problematic beneficiaries. 1. Reach out to all beneficiaries early in the administration process. 2. Make sure the beneficiaries understand your role as trustee. 3. Help the beneficiaries form realistic expectations for how long it's going to take to administer the trust and when they should expect their beneficial interests. 4. Keep beneficiaries informed about how you are managing trust assets. 5. Treat questions as opportunities for engagement. 6. Don't hide trust documents, assets, or other information from beneficiaries. 7. Be as transparent and communicative as possible throughout the entire administration process. Following these guidelines can help keep beneficiaries happy, and happy beneficiaries are far less likely to cause you problems. What's more, courts are far less likely to take issue with your administration of the trust if you've kept those beneficiaries well informed. What is an estate litigation attorney? An estate litigation attorney specializes in addressing, managing, and resolving trust and estate disputes, including securing protections from the probate court when necessary. These litigation proceedings can include any number of matters. For example, 1. Petitions for court instructions. 2. Petitions to recover stolen property. 3. Will contests. 4. Undue influence. 5. Financial elder abuse. 6. Fraudulent conveyances. 7. Testamentary capacity. 8. Breaches of fiduciary duties by trustees and other fiduciaries. 9. Accountings. And 10. Trust modification or reformation. Estate litigation attorneys can help people on both sides of these proceedings. For example, an estate litigation lawyer can represent a beneficiary suing a trustee over a breach of a fiduciary duty, or they can defend that trustee against that claim. When should I contact a trust litigation attorney? Professional trustees should contact an estate litigation attorney upon appointment to help them administer the trust, especially if it's the first time they've served. A trust litigation lawyer can help ensure that the private or professional trustee, fiduciary, understands and follows the relevant laws governing trusts and trustees. If you've recently become a trustee, you should schedule a consultation with an estate litigation attorney as soon as you're able. Retaining an attorney when you're first appointed can help you avoid a lawsuit altogether. If you're a trustee who's already being sued by a beneficiary, you'd be best served to contact an experienced litigation attorney to represent you rather than trying to engage or resolve those issues on your own. Have questions? We protect people like you every day. Call or email us anytime. The consultation is always free. Thank you for watching.